Everybody please silence your cell phones. Thank you. This is a regular meeting, a joint meeting of the Board of Supervisors of Poinciana West and Poinciana CDDs. It's October 18th, 2017. Let me start like Baldwin, my village drive in Poinciana. First item on the agenda is a call to order and a roll call for Poinciana CDD. Bob Zabardi is present.
David Lane present.
Lita Epstein present.
Good job. We have a quorum.
Okay, we need to call to order the Poinciana West CDD. Supervisor DeDeff.
Present.
Supervisor Brown.
Present.
Supervisor Rosenberg. Present. Vice Chairman Bento. Here. And Charlie Case here. We have a quorum.
Next item on the agenda is a pledge of allegiance.
Pledge of allegiance
to the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Next item on the agenda is audience comments. So I'll entertain audience comments for any item that's currently on the agenda. Please limit your comments to 3 minutes.
Thank you. I'm Norm Gundell, 419 Fountain Valley Lane. The fish kind assessment methodology report before you today lists special benefits from the proposed transaction. But most of the listed benefits do not require the issue of bonds or the levy of special assessments to repay them. There is no public benefit in paying to eliminate an illegal fee. The court will eliminate the fee without payment. There is no public benefit in paying to purchase property that must be turned over to resident control. The court will require turnover without payment. The various benefits of resident ownership, control, use, and enjoyment arise from turnover, not from payment. It is arbitrary and a breach of your duty to residents for you to pay for such benefits where no payment is required. As you know, I and others are litigating the club membership fee and turnover obligations. You have no well-founded belief that the club membership fee is legal or that this property is exempt from turnover because your attorney refuses to advise you on this. It would be arbitrary and capricious for you today to authorize filing for bond validation without first having a well-founded belief that the fee you would pay to eliminate it is a legal fee, and that the property you would pay to purchase is not subject to turnover. You should first require and receive a written opinion from your attorney, an opinion which he and his law firm will stand behind before you start today to impose this requirement, this repayment obligation on the residents. If you proceed today without first receiving a written opinion of your attorney, you will be in breach of your fiduciary duty to residents. Recall that Judge McDonald found that you did not know and did not consider the basis of the different assessments you imposed. You face the same result here if you proceed without knowing and without considering the legality of the club fee and the turnover obligation on the property. Finally, combining the new theater and wellness center with the amenities purchase bonds cannot save them. You do not need to issue bonds or levy 30 years of assessments for the new construction. 2 years of these same assessments will raise $11.4 million, more than enough to finance the new construction without issuing any bonds. And residents would save the additional 28 years of bond repayment assessments. Thank you.
Good afternoon, everybody.
Speak loud, please.
Gary Shula, Executive Vice President and General Counsel with AV Homes. Good afternoon.
Afternoon.
Let me begin by stating again that from day one, AV Homes has sought a transaction that benefited the residents of this great community. And yes, we also remain steadfast that such a transaction needed to be in the best interest of AV Homes and its shareholders. And we believe we entered into such a transaction that achieved both aims last December with you all. Mr. Gundel and his counterparts remain hyper-focused on the value AV Homes has received or will receive in this transaction, which continues to be mischaracterized in the community. As we've pointed out several times, after accounting for the various closing costs, assessment buy-downs, and assessments in O&M that we'll be paying on our undeveloped lots that we aren't currently required to pay, the overall value we'll receive in this transaction is expected to be less than $60 million. And that is a result of
Excuse me, less than what?
60.
50 or 60?
I said under 60. And that is a result, Chairman, of many of the concessions that you negotiated in the period leading up to the agreement. At a lower price, which has been suggested, the value proposition for AV Homes starts to fall apart. We end up being better off operating the club in its current form or exploring alternative opportunities. But regardless, shouldn't we all be focused on the value to be received by the residents in the form of lower payment and new amenities? That's what we want. To that end, despite the continued efforts of a few individuals to frustrate the transaction, most recently through the class action lawsuit that he referenced, there continue to be two options on the table that I mentioned several months ago. We either move forward with the transaction that benefits all parties involved, or we don't. Whether or not the transaction is consummated, we will fight the separate lawsuit that Mr. Gundel mentioned to its conclusion, and we'll also assert our counterclaims that we have filed. And a couple of points on that lawsuit. As part of their efforts to interfere with the transaction, the plaintiffs have suggested the club is somehow an HOA, which Mr. Gundel alluded to in his comments. It's communicated separately. We don't believe there's any basis for that in Florida law whatsoever. And we're working to put that very issue before the judge as quickly as possible. If they truly believe that we're required to turn over the amenities at a future date, and that the club is actually an HOA, they'd be eager to get those issues in front of the judge as well. Instead, I suspect they're going to attempt to delay the transaction further. The truth is, when you purchased the home in Solivita, Mr. Gundel, like other residents, agreed that the terms of the club plan and the charges thereunder were fair and reasonable given the nature of the amenities. They agreed that AV Homes would not have conveyed the property at the price it was conveyed if it weren't for their ability to charge those fees and recover the substantial sums we invested in the community, and also to eventually earn a profit. They agreed that the provisions of the club plan do not grant any ownership right to the HOA or to any individuals. And they agreed that AV Homes has the right to sell the club in the future. That's what was agreed to. That's what you agreed to, and now to take a contrary position is disingenuous in our view.
Sir, if you
Okay, I want to switch gears to a couple of positive notes that I think the board will be interested in hearing. The first one, you'll see in the agenda package, there's a proposed amendment to the purchase agreement. One of the main purposes there is to eliminate the equalization concept, which was the sole basis for projecting down the line. Not validating the bonds. We've heard concerns from some of you, which are very fair, asking how we're going to ensure that we maintain our commitment to each resident to pay the assessments at an amount no greater than the 2016 membership fee. We share that concern. And we haven't finalized an instrument, but our plan is to record a beneficial covenant before you finalize the assessment methodology in December. Record a beneficial covenant on each of the roughly 1,600 impacted lots, agreeing to buy down assessments for those homeowners after closing, ensuring that they will receive exactly the same value proposition as was contemplated in the original assessment methodology. That will be being enforceable. Yep, one more paragraph.
We have given other people additional time. We'll give Mr. Shula additional time.
Thank you, Chairman. This will be an enforceable right for those affected residents and will only be conditioned on the transaction closing or being terminated. It's not something we'll be able to revoke. Final point I want to make, we've heard from many of you, board members, as well as a few residents, that the 5% project management fee contemplated in the construction management agreement is objectionable. We think that's market rate, and we thought it was fair, but we also understand that there's been delays to this transaction that are outside of your all's control. During that same time, construction costs have gone up, so we agreed to replace the project management structure with an employee leasing agreement And as a result, I would expect you're going to see an additional $500,000 in the project fund for new amenities. This should provide you with more flexibility as you evaluate the new amenities and improvements once we're able to move forward with the transaction. Thanks to all of you, and look forward to continuing to work with you.
Thank you, Mr. Shulo.
Joe Stevich, 457 Palace Verde Place. Good afternoon, everyone. We're all together here after about 2 years invested in this transaction. And there have obviously been many issues raised since the signing of the contract. We must recognize everyone's rights in this regard, and we do so sincerely. We've heard many folks badmouth not only the transaction, but the participants, meaning the board members, the board attorney, and AV representatives. 2 lawsuits have been initiated, with one hopefully being mostly resolved today, while the other, supposedly brought on behalf of all residents, could drag on for a long time. This class action suit, supposedly in the best interest of the residents, has morphed into your typical class action where a bunch of lawyers gang up on a target situation, hoping for a piece of a settlement. I understand additional lawyers have joined the team on a contingency basis. I will get a little sarcastic here by stating I'm sure they have the best interests of all Solivita residents at the heart of these efforts. The majority of class action suits get dismissed at some point. A bunch settle for many reasons, including just making it go away, while hardly any ever go to a judgment in court. Even so-called successful class actions rarely benefit the individuals in the class to the extent it does the lawyers, or in a manner consistent with what we might be led to believe could have happened. This suit appears to be geared toward opening a window for these lawyers for further actions all across the state of Florida, where developers own and control amenities. Yes, we understand that different residents can just bring another action after this one if it goes away. Numerous folks have criticized our board members personally and professionally and claim they are married to AV and do not have the best interests of their fellow residents front and center. Give me a break. Someone files a complaint with the AG because Lenny spends so much of his so-called free time making sure his neighbors understand the intricacies of the transaction itself. Lita researches and provides information to residents far beyond the matter of the amenities itself. Then we have a fellow resident, whom I will not name because I didn't ask him, who has extensive business and real estate experience, get up at almost every joint meeting to respectfully address the contentious issue of price. On top of that, does anyone actually believe that Dick Kellogg, who has been and continues to courageously battle serious cancer, actually comes to these meetings to unjustly enrich AV, or wants to hear folks degrade the board members, or he has absolutely nothing else to do? No, he's here because he believes it's the right thing to do for us. We all need to step back and learn from Dick what life is really about. Thank you, Mr. Kellogg. Do some really think our board members put forth all their time and effort because they are beholden to AV? Of course not. It's also amazing that some folks strongly put forth the notion that AV is just taking advantage of us. Why would any for-profit company, especially a publicly traded company, which itself is actually beholden to its customer base in order to survive and continue to build a positive reputation, take action geared toward negatively impacting the very core of their existence? It's time we come together for the right reasons and put forth the effort to bring this matter to a satisfactory conclusion so we can move forward and enjoy our time here in this wonderful community. I sincerely thank the residents for putting up with me and all who are active in this matter, and especially our board members and AV reps who have worked tirelessly to make our lives here in Solivita the best they can be. Thank you.
We have any other Okay, there being none, we'll move on to the next item, and that is approval of the minutes of the August 16, 2017, and September 20, 2017 joint board meetings. Supervisors have received a copy of those minutes. Are there any additions, corrections, or deletions?
There is one, I think, on, I'm sorry.
Any from the Poinciana CDD?
Yeah.
Yes.
On page 3 of the minutes,
Which one?
okay, which was fifth order, sixth order of business.
Which date, August 16?
Yes, August 16th,
Okay.
right. We talked about the negotiations with Spectrum, and I'm concerned as to whether any updates have taken place with that regard. Craig, anything with you?
The communication we've had with Spectrum, they put together for the HOA behalf. Can you guys hear me now? Yes. All right. They put together a bulk rate for the cable and internet. We do have that. I think it's $55 a month. Is that right, Gary? That's something right now to the HOA side that we looked at. But as far as the Spectrum for the clubhouses and stuff like that, our Burnside is working through that. They have not provided pricing at this time. As you guys know, Spectrum has been a mess. We're dealing with that right now too as well. So that's the update.
To be continued. Anything else? Okay, there being none, I have a motion to approve the minutes of the August 16, 2017, and September, whatever the date was, 2017 minutes.
Dick Calhoun, so moved.
Peter Epstein, second.
All in favor?
Aye.
All opposed? Motion carried.
Okay, for the CDD Poinciana West, are there any additions or corrections or deletions to the minutes of August 16, 2017, September 20, 2017?
I have something on September 20th, on page 4. It refers to me being in favor of stepping back and reconsidering everything. Never did I say that. So I think I was mixed up with somebody else.
Make that correction.
I need to make that correction, please.
Supervisor, could you just take me to the page 4?
Page 4, September 20th.
Got it. Any other questions, comments? If not, I have a motion to approve.
Motion.
Is there a second? Okay, all in favor?
Aye.
Opposed? None? Motion carried.
Does the Poinciana board need to do anything with that correction that was made as we approved minutes before that?
Yeah, you can just go ahead and you can approve it with that correction. You approve it, it'll be twice, but at least that you'll sign off on that.
Motion to approve those minutes with the correction that the Poinciana West CDD board made.
So moved.
Second.
All in favor? Aye. All opposed? Thank you. Okay, next item on the agenda is discussion of non-amenity district business. First sub-item is a discussion regarding district staff contracts. As all board members may be aware of now, that we've had changes in personnel in both the district manager position and the district engineer's position. And the question at hand is whether we want to go out and consider going for proposals for other companies on these two positions, or even include the district council position also. So, what do we think?
The history now is, these are all, how long have all these positions been without any type of contract to see whether we've got valid pricing for the current? Have all been here for more than 8 years?
I don't know.
We haven't got any kind of request for proposal for, as far as I understand, at least 8 years.
Well, yeah, I'm concerned about the change in personnel now. This is
Well,
not
yeah,
the
right, but I
time
think
for-
that is, because of change in personnel, I think, given the time that we haven't even looked at contracts for that many years, it would be, I think, prudent for us to be at least doing requests for proposals and seeing what other options there are in the way of getting those services.
I would agree.
What,
From my point of view, I think it's an opportune time also to get additional proposals. There's been some major changes. And I think it's incumbent upon us to seek out some information.
I think so, that we also need to take a look at the core competency of the companies that are going to be doing the submittal proposals and their ability to be able to handle the additional duties and responsibilities if the sale of the amenities does go through. And we are going to have additional responsibilities on both boards that are going to have to be considered.
And I know I did some research on that, and there's only 2 or 3 companies that actually can handle both amenities and the water
Well,
ponds.
I think we'll leave that recommendation to our attorney who will look into that
well,
marketplace.
let's start out one at a time then. If we're going to say, yes, we want to do this, now let's look at one at a time. First is district manager's position. Is that the one you're referring to?
Yes.
Okay, and we'll have to ask our district council to look into those, and you can feed your recommendations that way.
Yeah, just so the board is aware, there's probably a handful of companies that do this type of work throughout the state, and certainly, I tend to agree with Lita, there's only a couple that really do the amenities as well as the district management side, which is largely an accounting, exercise, which is a very important one and complex one. I don't mean to belittle that. So from a process standpoint, these are all different processes. So for district manager, it is considered a contractual service under Florida law, and you're not required to competitively bid that process through an RFP. Typically, when districts want to look around and see what else is out there, they direct legal counsel to reach out to the 5 or 6 firms who do this type of work throughout the state and ask them to prepare a proposal, which we would then bring to your next meeting. You can do an advertisement in a newspaper, but I think because there's only a handful of companies that do that, you're probably going to have better luck with asking us to reach out to them versus posting something in the Lakeland Ledger. But that's certainly your call on how you want to do it.
Yeah, directing
I
legal staff.
like counsel.
Directing you.
Yeah.
How does Wes feel about that? Okay.
Okay with that? Anybody comments? Yes. Okay,
So you, would you do that for us, please?
Yes, we can do that. We'll bring that back to your next meeting.
Don't need a motion?
No, I don't need a motion because you haven't made a motion to terminate your existing contract, nor is that, when I hear anybody recommending, you want to see what else is out there. And we can go ahead and informally request those proposals and bring them back to the board.
When is that contract up?
I believe that contract has a 60-day termination provision without cause or a more immediate termination with cause. I will tell you that it takes some time for the accounting records to be transitioned and everything, and so I would not recommend you do anything with that contract today until you look at what your other alternatives are and then allow for that 60 days to be able to transition those records.
Okay. So the next one would be district engineering. Do we want to go and look for proposals or the same type of thing from district engineering firms?
I would think so. I think that, again, looking at the ability to handle both the CDD current responsibilities and the additional with the amenities is one that I think is very, very important for us to be able to function easily or have the ability to have a engineering firm that can handle both sides. So, same reason.
I agree.
And that process is a little bit different because it falls under the Competitive Consultants Negotiation Act. And you have to do an advertisement, and then you have to receive qualifications, and then you have to rank them based on qualifications, not price. And then once you rank them, you start negotiating price with the top ranked proposer, and then work your way down if you're unable to negotiate something. So that's the process you go through there. If in fact you want us to go through that process, I would ask for a motion from both boards, individual motions, to direct staff to initiate the RFQ process for district engineering services.
So moved.
Dick Kellogg, second.
Second.
All in favor?
Aye.
All opposed?
Okay, You?
Second the motion. I make the motion.
All right, do I hear a second?
Second.
All in favor?
Aye.
Motion carried.
Mike, one question, and Kathy Leo's proposal that we have in front of us, that will be held in.
No, that's for interim services. That's separate.
Yeah, and so, we have that issue with interim services, and then, the board needs to, give some direction in terms of, if you want to do anything with district council services.
Yeah, that's
And if so, if in fact the board does decide to do that, we would not be involved in that process, and I recommend you have, either your engineer or your district manager, run that process.
And if I could just clarify your previous point on district engineering services. Would you like district council to do that process or the district manager? I like.
The district council, from my
That'll be
understanding.
fine. That'll be fine.
Yeah, we'll do everything except run the ad. And then, the proposals as they're received, we'll have them received at our office and we'll get them to you for the agenda package.
From a personal standpoint, I'm in favor of leaving the status quo with our current engineering until we go through the RFQ process and we decide where we're gonna go on a permanent basis if we make any change at all.
In light of the litigation we're faced with, Dick, I couldn't agree with you more.
I think we all agree on
You said district engineer?
that. Keeping
Yes,
the
yes.
district engineer on an interim basis.
No, you're,
We're
that's.
not there yet?
Not there yet.
Where are we at? Tell me where we are.
Talking about keeping package, I think we want to look at this
Yes.
option. So we look at this option.
We want to visit the option.
Right, so we want to do the option.
Okay, so tee it up.
But I think when you talked about the legal issues that we're dealing with now, you're talking about not changing our legal representation at this point.
That's the next question. What do we want to do about district legal
All right.
counsel?
Then that's what I'm saying. I said with all of the litigation. Yeah, that's what I thought Dick was saying.
That's correct. You're ahead of yourself.
I thought we did that already. Sorry.
No. Dick says that we keep the Atkins on until after, or if.
Through the RFQ process and the approval and denial, of which one we choose.
Okay.
I think it's prudent.
So the answer to that was yes. Now we move on to district council. Does the board want to do anything with district council change at this
Not at this
point?
time.
Not at this time.
Okay. Okay. Now, so that ends that discussion. Next item on the agenda is 5B, consideration of a proposal for interim engineering services from GAI Consultants, which is the new firm that Ms. Leo, our former district engineer representative, has moved to.
I think we already answered that question.
Okay? So the answer is,
Clarify what you think the answer is.
The answer is we use Kathy, we retain Kathy on an interim basis until we finish the bond, or until we finish it.
No. We already decided that. We already decided that we were gonna maintain the status quo with Atkins through the RFQ process and decide at the time that the RFQs come in as to which engineering firm we're going to go with. But for now, we maintain Atkins through that process.
But if we do that, then we lose the services of Kathy, who knows the process and what we've been planning for the last 2 years.
I think that the staff at Atkins is probably just as competent.
no, this is going.
No deference to Kathy's.
No, but not to lose that expertise, why not put it under contract on an hourly basis, done in and not to exceed? I don't see any problem with that. If we need help, if we need the assistance, it's there.
That's why we're discussing it right now. You know, if we want to do that, if we don't want to do it.
That's what I'm saying, that's what this proposal.
I want to keep Kathy through the process until we finish it.
Well, on a not to exceed amount,
Okay.
I think
What
that's
would that
right.
not to exceed amount be, 25,000?
yes.
To Bob's, the chairman's and board's point, I think that's that's a need to help us through this transition.
Sure.
Kathy's been so deeply involved, so I'm in favor of it.
But as far as RFQs for different engineering firms to consider, that's a different subject.
Okay, I agree.
Okay. So the answer to that is, yes, we want to do that, so we're going to need a motion for this interim engineering services.
The Kellogg, so
Second.
All in favor?
Aye.
All opposed? Okay, does West have to agree to that also?
Well, West has to consider it, and if they want to enter into an interim agreement, then they can as well.
Okay, there's a motion to approve Kathy's firm for an interim agreement. If anybody would care to make a motion in that respect?
Bill Brown, so moved.
Do I hear a second?
Shirley Stepka, second.
All in favor?
I'd like to call a question on that, and that's $25,000 combined between both boards, correct?
That's what was my question too, actually.
Well, I think I have to let Kathy speak to that, but I thought it was separate, but understand that the amenity fees are paid by Poinciana, not by Poinciana West, and then they're ultimately funded through a funding agreement with Avatar. So I would anticipate
So it's a moot point.
the bulk of the charges over the next 2 months will be through Poinciana.
Okay. Thank you.
We good? All right.
Congratulations, Kathy, on your new job.
Next item on the agenda, discussion of bond validation, special assessments, and bond sale process moving forward.
If the board would indulge me, I've got several items here I just want to kind of give an update on, and then we'll move into the process that's outlined in the rest of the agenda. Number one is, the board is aware, the district prevailed on 4 of the 5 items in the validation case. The one item we didn't prevail on was dealing with the assessment equalization payment. And as I told you at the last meeting, one of the options is just eliminate that concept and redo your assessments, and that's what this agenda package is set up to do. Been a lot of talk in the community about how the objectors to the validation won that case, but despite that statement, they filed an appeal. So they're appealing right now the district's inability to issue the bonds, which is fascinating. So right now there's an appeal pending before the Florida Supreme Court. Both Dr. Kessler and Taylor and Mann have filed an appeal, and that's on a briefing schedule of Dr. Kessler's filed his initial brief. Taylor and Mann are required to file their brief by October 31st. The district then has to file their responsive briefs within 20 days thereafter, and then there'll be a short time for a reply, and we will try to get in front of the Supreme Court for an oral argument. So that's the status of the original bond validation case that apparently was won, but is now being appealed. So
When did we get that notice? When did you get that notice?
we would have got that notice of appeal, it would have been a couple weeks ago. In terms of the actual notice, we didn't get the brief from Dr. Kessler until a couple of days ago, and then we have not got the brief yet from defendants Taylor and Mann.
Okay.
So that's the status on that case. And again, the district did not appeal. The district chose instead to change the concern that the judge had and just go through the process with the simplified methodology. So that's not the district holding up that process. Number 2 is I've been asked a lot in terms of class action. There's been a lot of misstatements out there in terms of the class action, and I will just say this. Number 1 is based on a statement that was made by an attorney for the folks who have filed that. I'm not convinced they believe in the class action, and I'm just going to leave it at that right now. Number 2, there is a second amended complaint, and then Avatar has filed a motion for summary judgment on that class action case. Again, from everything I can see, Avatar is trying to expedite the resolution of that case as quickly as they can, based on what I can see. And then finally, one of the things that isn't being talked about, and I looked at the class action complaint, and one of the questions that was raised to me, which I think should be a concern, and I'm not sure if anybody's talking about this, is, if in fact the court were to find that the club plan was illegal, that may mean that all your assurances that your fees won't go up would be found not to be effective. And so if the result of the class action was that, that the club plan was not allowed to be in place, but the court did not order AV to turn over all the facilities, the community really needs to think about whether or not that's a position that they want to be in, where they don't have the assurances of the club plan, and they don't own the amenities. So nobody's talking about that, but certainly, at least in my review of the complaint, that's one of the potential results of that. So I would encourage you, if you are asked about that, try to figure out what is the answer to that question, because certainly that can have an impact on this community if you have no protections in the club plan and you don't own the amenities.
Wouldn't that be the same condition if this were sold to a third party? The club plan would be dissolved and you'd have no assurances that fees wouldn't go up?
No, if it were sold to a third party, the way that I view the club plan, that the third party would take over the club plan and be the club owner.
Would have to? Would have to take over the club plan?
I think at this point in time, unless you just sold the assets of it, but you want that revenue. So no, I think it's a different scenario.
Okay.
Number 4, in terms of negotiation, we're going to go over the purchase and sale agreement here today. I will tell you that in my experience in the past, there's not a lot of business owners who are going to negotiate a lot on a lot of issues when there's pending litigation out there. So although we have made some headway and AV has made some concessions, which I think are very important for us actually realizing the improvement plan that you all looked at 2 years ago, certainly there's not going to be a whole lot of substantive negotiation